Well, I would like to do the introduction again because I think there were some technical difficulties. So I apologize about that. So welcome everyone on behalf of LexFest Foundation to this policy dialogue session on Forest Rights Act 2006. We have with us today Mr. Nitin D. Rai. He's a political ecologist with extensive research experience, primarily in the domains of state conservation policies in India and its impact on the livelihoods of communities. Thank you for joining us today, sir. Very warm welcome to you.
Thank you.
And I will be moving on directly to the questions. And if the audience member, if you guys have questions, please write them in the chat box below. So we'll be taking them up as and it has been 14 years since FRA has been passed, right? Since 2006. And since it has been passed, the implementation of FRA has been one of the biggest issues that the Act has faced. And with regards to that, there were two interesting things that I noticed. One was that the northeastern states of the country, say Meghalaya, Mizoram, Nagaland, they have not implemented their FRA despite having notified forest covers and substantial tribal populations, because they, according to them, they already have alternate systems or indigenous systems which provide them access to community forest resources. And the second thing, among the states in the country which have already implemented the FRA, majority of the focus has been towards granting individual forest rights instead of focusing on community forest resource rights, which I think is arguably the most important set of rights that the FRA grants. So with regards to this, I have two questions. One, what potential or what is the value of FRA? What can be the value of the implementation of FRA in northeastern states, since if they already have alternative systems as they claim? And second, among the states which have already implemented FRA, how can they be incentivized to focus more on community forest resource rights instead of mere individual forest?
Okay. So very quickly, I'd like to reprise for us the spirit behind the Forest Rights Act, and ask ourselves the question: what then are the barriers to its implementation today? The history of alienation of forest people from forests, it goes back to 150 years. The most recent history, which is the British colonial alienation of forest dwellers from the forest, because the British wanted these forests for timber. And so that was really the reason why in the 1860s, you had a denial of rights to Adivasis specifically, but also broadly a larger number of forest dwellers, which in the Act is that category of people referred to as other traditional forest dwellers. The British colonial enterprise for timber extraction was largely in peninsular India. You know, the central provinces of Madhya Pradesh, Orissa, Bihar, and of course, then across the entire country in the Western Ghats, where I am from, and so on. So you've got 150 years of systematic denial of rights. Now, the Northeast was different historically, in that the local village forest councils and the Gram Sabhas, which of course they have their own names depending on the autonomous region that the Adivasi, the northeastern folks are in, they had control over these forests. So the British were not able, and also because of the less interest in the kinds of forests that existed in the Northeast, the hill forests, they were difficult to access. And the Naga rebellion, and you had periodic skirmishes with the British that so the British didn't and weren't able to usurp, in some sense, those forests like they did in peninsular India. So you've got a very different trajectory of alienation of the local communities in the peninsular and in India. Peninsular India is sort of the more, I suppose, convenient word one could use, than in the northeast of the country. So you've got a history of systematic denial of rights to Adivasis. While the settler, the agrarian communities were given rights to land and ownership, Adivasis were denied these rights to land and ownership. So that really explains for us why you see this difference between here and there. So the Forest Rights Act is the first progressive legislation that begins to understand that this systematic alienation needs to be repaired. And so the preamble, for instance, of the Forest Rights Act says this is to repair historical injustices that were done to Adivasis and other traditional forest dwellers. And so therefore, it's more pertinent for a whole range of forest dwellers in Indian forests. And so depending then on current systems of control and ability to manage their forests, the FRA then differs in its applicability and interests of Gram Sabhas to therefore access the provisions of this act differs. So I hope that answers your question, Pamela.
Yes, yes, sir. Thank you so much. So,
I just, sorry, before you get in, I forgot to answer the second part of your question, which is,
yes.
how do you incentivize? I have a problem with that word incentivize in the first place. I mean, it smacks of instrumental and, you know, I mean, although it's common, it's a very common word. I'm not debating the fact that it needs to be used, but I'm saying I personally have a sense that if the Forest Rights Act is to repair historical injustices, then that should be, of any democratic government, the first step in understanding that these people were denied rights for many, many generations. And now the Forest Rights Act begins to put them on the table. And so the first thing that you need to do is both the IFR, which gives them rights to cultivate land, and CFRs, which gives them rights to access the forest for a whole range of resources, needs to be done. That's a democratic and required process. Now, the question of incentivizing, if you look at it slightly differently, which is a point that many international institutions have been making over the long term, which is saying that if communities had more rights to the forest, then they're better able to manage the forest. A recent report by the Rights and Resources Institute actually says that even if you look at economically speaking, local communities are able to manage their forests for far less amount of money than state departments, because you've decentralized and enabled a whole range of people on the ground to take care of the forests using their situated knowledge, using their residence in these forests, and so on and so forth. So different people have argued differently: economic reasons, historical reasons, social reasons, and ecological ones, because there is again another report which says that forests are better managed, better governed, and have more biodiversity when local people are given rights to these forests. And these studies don't come from India, because we don't have cases of enough number of cases over the long duration of local management of forests, except in the Northeast. But these come from a whole range of other countries: Mexico, Colombia, Brazil, and Indonesia and Malaysia and so on. So you do actually have cases internationally if we did want evidence for how local management is important along a whole range of dimensions, like I said, social, ecological, economic, and historical, political, and so on. So that's, I think, imperative on governments to push the implementation of an act that gives rights to local communities that have been disenfranchised and alienated for generations, like I said. Pamela. Okay, till Pamela comes back, let me continue talking about my own experience in the implementation of the Forest Rights Act in a particular tiger reserve in South India, in Karnataka, actually. And this was uh, uh, an area in which an Adivasi community live in, called the Soliga Adivasi. And that we started working, at least my own experience in BRT, which is the Biligiri Rangaswamy Temple Tiger Reserve, was in 2004. And they were, for the first time in the country, in 2011, Adivasis were given CFR rights for for under the Forest Rights Act, and they've been able to exercise these rights variably because it also became a tiger reserve at the same time. So there's been a lot of friction between the forest department and the Gram Sabhas in being able to exercise all of the rights that they've received. The IFR seemed to be, like Pamela said, a much more clean and implemented provision of the Forest Rights Act, but not so much the community forest rights provisions of the
Yes.
Act.
Hi, Nitin. So I'm Tanya. I've also joined this session because there seems to be some problem at Pamela's end, but I'll be joining through audio. So I'm sure I'm audible, sir. I'll be taking
Yes,
it
you are.
forward in case there's a glitch with her connection. So,
Sure.
so there comes in the issue of women who have historically played a key role in many forest dwelling communities, often bearing the responsibility of collecting MFP like bamboo, tendu leaves, etc. So recognizing this, FRA mandates the representation of women in the Act's implementation in institutional structures like Gram Sabha, DLC, etc. And at least 1/3 of the minimum quorum for Gram Sabha meetings must consist of women as per the Act. But in this respect, our question to you is, there are again two questions. To what extent has the inclusion of women under the Act successfully translated into actual practice? And a veritable shift in women's access to forest resources? And is there a need to provide additional rights to women in forest dwelling communities over and above the ones that already exist under FRA?
That uh, unfortunately, I'm not able to answer the question in the spirit in which it's been asked, which is,
Okay.
there needs to be a very clear gender perspective beyond what has already been
Yeah, but generally, so if
delineated.
we can take your comment on the way it exists in the Act, do you think it's been done justice to? What does your research show, that has it improved some way women's participation at Gram Sabha level, the tribal women who come under the ambit of the Act?
I certainly think so. Not enough, maybe, but given what my own experience has been, that in many, not all,
Okay.
certainly in the communities that I've worked with, that most of the traditional, the customary institutions are male dominated.
Hmm.
And in meetings after meetings that we've had in the past, they were all men. It was striking how much of the attendance was completely men. And if it wasn't for a mandated constitution that said, women also need to be part of Gram Sabha meetings, of the committees, and also, as you know, the title is given jointly in the name of the male and the female household, elder in the household. So it is a very clear stated idea in the Act that we need to see more gender parity. I'm beyond saying that we've seen, for instance, more participation by women in the Gram Sabha meetings, in the committees, because of the nature of the Act itself and the fact that it mandates greater women's participation. But I still think that, as we all know, in every sector of Indian rural and urban livelihood and society, we could be doing a lot more on this issue of gender representation in forest management. there is, a constant invoking that women have better relationships with the forest and so on. And I think this ecofeminist perspective, while important, can't be relegated to only those sorts of functions, such as gathering and harvesting, tendu, and so on and so forth. But it needs to be part of the entire chain of governance, such as in decision making and in organizing meetings and so on and so forth. So the act is certainly a first step, but I think we need to go much further.
Okay. And I think I'll ask you more specific questions, which are to do a lot more with the kind of research and work that you engage in. So when we talk about conservation rights and with respect to, like in 2006, the government added tiger reserves as a new legal type of protected area, amending the Wildlife Protection Act, which consists of critical tiger. I mean, there are a lot of technicalities under it, but with respect to FRA 2006, it denotes that such areas of national parks and sanctuaries where it has been specifically established case by case basis on scientific and objective criteria, that such areas are required to be kept as in violation of wildlife conservation, and it may be determined by the central government. So, but in this respect, for instance, an article published by DNA India highlighted in 2017 that National Tiger Conservation Authority of the Government of India ordered against the recognition of forest rights in critical tiger habitats, along with several examples of how communities have been repeatedly evicted from tiger reserves. So, is the notification of CWH through the FRA a critical intervention that can potentially impact the continued tussle between wildlife conservation laws and forest rights? What is your take on that?
Okay, I have a take on the critical wildlife habitat. Many conservationists have argued that, oh, here is a provision in the Forest Rights Act that sets apart areas of protected areas, right? Sets apart the core area, for instance, for conservation. And once that's done, it cannot be denotified or diverted for other purposes. So therefore, it's a very strong conservation provision. My take is that it still affects the Adivasi communities, because after the identification of a critical wildlife habitat, these communities, households, villages have to be then relocated for conservation. Now, the work that I've done, my team has done in BRT, shows that the entire forest in BRT, 540 square kilometers, for instance, has been produced by BRT Soligas. So what is the question then of the inviolateness of the forest for tiger conservation or for wildlife conservation when these forest itself has been managed over centuries by Soligas and produced by them, by their customary activity. So this question then of inviolate I'm proposing, and I've written about this, it is not based on science. Because if you look at the history of these forests, they've been produced by people burning, cultivating, or conserving, protecting parts of it, using other parts of it, and so on. It's the number of cases are varied, but the practices seem to fall under this idea that local communities produce these forests, and therefore the question then of inviolateness, which is to keep these forests free from people, is a very new one, and it was used for the first time by Indira Gandhi in 1972. And Jairam Ramesh actually writes about it in his biography of Indira Gandhi called A Life in Nature. And we see it mentioned by Indira Gandhi, not a scientist of any standing that I know of. And then it seeps into policy, it seeps into science, it seeps into writing, it seeps into wildlife management protocols. So the idea of keeping these as pristine wilderness is a very new one, and it's not scientifically valid. So rather than that, we need to think of these as co-managed areas. You know, how do you use local knowledge, community presence to produce a completely new way of governing these systems. And one other thing, you know, if we needed data for this, for instance, if you look at the recent tiger estimation report that was produced by the National Tiger Conservation Authority, and if you look at tiger reserves where people have been completely removed, you know, such as Corbett, and tiger reserves where people still continue to live within, such as the one I work in Biligiri Rangaswamy Tiger Reserve, or in areas such as Bhadra where people were removed. There is no relationship between people's residence in these and tiger numbers. In BRT, tiger numbers have gone from 35 in 2010 to 69 in 2018. So you've got a doubling of tiger numbers, despite the fact that people have lived within this. So I don't think there's enough basis for this idea that areas need to be kept inviolate, because then the social implications of relocating people from these areas is very high. So going back to your question, Tanya, very quickly, I just want to add that the provision was put in my reading at least, almost as a sop to the conservation sector. Why should a social legislation, in this case, a Forest Rights Act, which was shepherded and shepherded by the Ministry of Tribal Affairs, have a conservation provision, which was far more stringent than any legislation in the Ministry of Environment and Forests. So it just seems confusing to me. And therefore undermines, in some sense, what the Forest Rights Act is about.
Yes, sir. I completely agree with you on that point, sir. And audience members, I would encourage you to ask more questions of sir. As of now, I will take up this question by Mrigakshi for you, sir. She asks if what have been the reasons because of which we have seen there's a hindrance in extending rights to locals when it comes to forests in India, and what have been some successful practices in other countries in this regard, and why is it that India cannot go for those reasons and those motivations?
One is historical, as I said, and we just seem to be stuck in this trajectory that was handed down to us by colonial British forest administrators. It's easy to demarcate forests at reserve forest, protected areas, tiger reserves, national parks, sanctuaries, and keep that inertia in law and in practice, and keep the received ideas that local communities damage forests, right? And that's a historical and a convenient colonial practice. You know, the science behind slash and burn agriculture, for instance, being bad, or the science, the non-existent science, but the received ideas that fire was bad, was a very British one. So one of the reasons I think is a historical one, that that local communities cannot be given rights. But under that historical is a more political economic reason. And that is that if you have control over that territory, which is the reserve forest or a sanctuary or a national park, then you can get all of the returns from it. In the past, it was timber. Today, it's tourism, right? The returns from gate fees in Corbett, for instance, are humongous from tourists coming from Delhi and everywhere else. So, you know, you don't want to lose control over those revenues. Another big revenue that I think the Indian government is looking at is from carbon credits and carbon and REDD+ investments, and to meet the INDCs under our climate agreements and under Paris. So, you know, if forests were then going to produce all of this carbon, and you need to report the sequestration of carbon to international agencies, then you want to do it under and in territories that you have control over. So if you gave Gram Sabhas and if you gave forest dwellers rights for governance, then you lose the ability to be able to do a whole range of things that you have agreed to internationally, such as so the examples across the globe are enormous in terms of, like I mentioned, the Rights and Resources Institute's report on, again, carbon sequestration rates by community councils in 6 countries that they've looked at. I can't remember the exact countries, but Colombia and quite a few South American countries, which didn't have the sort of historical colonial forest administration that the British had here.
Okay. And in the same vein, sir, if you can take up one of our own questions, which is to do with how do you now see, since we are talking about carbon footprint and how tourism or any of the commercial interests and how they impact forest rights or forest dwellers. So how do you think the EIA and the latest, the way the notification has come out, how will that impact the implementation of FRA? And consequently, how will that affect the rights of forest dwelling communities?
I should have brushed up my my scant understanding of the EIA.
If I can just
bill that
give
was
you
passed.
context here, sir, the latest notification that came out sometime last year, I think by the end of it, and there was a lot of hue and cry around it, was to do with now the government can enter a lot of what earlier were restricted zones with respect to conservation in the name of economic development. And a lot of projects in national interest can be taken up in those areas too. So
Right.
the earlier what was avoided, or at least activists were trying to avoid, what was done in Goa and before that Maharashtra. So while those cases are still pending in the courts, respective state government courts, I think after the new notification, activists and researchers, they suggest that this will be a big blow to forest rights, even to our conservation efforts with or without the rights of human beings involved in that.
Right.
So it's in that context that I talk about FRA has a lot to do with, they claim that the concentration is on the rights of people who live there vis-a-vis their conservation efforts that are going on in the forest without external interjections, so to say. But in that light, how do you see that this will now affect the implementation? Because obviously the notification doesn't take this into consideration at all. They're just talking
Right.
about
No,
commercial interest.
yeah, no, it's fascinating because in 2000 and, when Jairam Ramesh, I forget the year now, when Jairam Ramesh was the minister, he actually passed a circular, a GEO, that said that all diversion needs to have the permission of the Gram Sabhas. You have to have
Yes.
a quorum, a meeting, and the Gram Sabhas to approve forest diversion. And that was
Yes.
an extremely progressive MOEF GEO when
And
it
in
did.
fact, so sorry to interrupt, but that's precisely what, that those are also parts of public consultation, which has been done away with under the new notification. They
Exactly.
said it's not a compulsory
Yeah,
requirement. So yeah.
exactly. So the question here, I think, is going back to then the previous question about the FRA, and it's, and how people conceive of the FRA as being anti-environmental, right? That it's degradational and so on. I think we need to look at it and take a more political position here, and ask the question: the real forces that are out there that are undermining both environmental and social outcomes is corporate interests, right? And it's a whole range of developmental interests. And I think we need, therefore, to come together and understand that the larger drivers that are going to affect people and landscapes and forests, and therefore people who are now hindering the Forest Rights Act, such as conservationists, in the Supreme Court, for instance, who have filed a petition against the act and challenging its constitutionality, should understand that only when you have local communities also given some rights, when you sort of decenter and complicate the authority on forests, and not only vest it with the state, can you then slow down diversion of forests and a whole range of these sorts of interventions, such as the one in the EIA. Because when you give the state all of the power to govern these forests, that's when you're beginning to see the problems, right? So we need to have decentered. You need to have gram sabhas also in the decision making process. Uh,
And in again, in the context of exactly what you're talking about, I think there's a question, sir, which you have already answered. Dr. Tawasif asked about how exactly does Forest Regulatory Act or giving away rights affects the negatively impacts the departments of forest and wildlife. I think that's precisely something you were talking about, that we have to understand that is not an adverse impact. So in this respect, so when you're talking about giving more rights to Gram Sabha, how exactly do you think that the kind of power that bureaucracy has with respect to forest, the implementation of FRA, or with respect to community rights, the way the diversion activities as they are undertaken, mostly the power lies with the bureaucrats who work in these districts. So what do you suggest could be some major pieces of legislative, or even within the present act itself, if we can suggest some amendments through which there can be better, more power given to the Gram Sabha, more authority in terms of diversion activities, and also, of course, which is directly then related to the rights of the people living in those forests?
yeah. So I think the that's a big question, because I think in 14 years, as you said, when we opened this session, in the 14 years that the act has been in place, it has received challenges of all kinds. You know, in in just the minimal offering of rights, not even ownership. These are rights, user rights. You know, it's rights to cultivation, it's rights to harvest, it's rights to worship, it's rights to manage and regenerate and govern, and so on and so forth. The forest department, even in the case of the IFR, the forest department retains the ownership of that land. Okay. Now, Adivasis who are given rights to forest don't own it. For instance, one of the problems has been that they can't then approach banks and use the land that they've given as collateral against loans, for instance. Or they can't attract schemes from the government that are targeted for rural private land and so on. So this is a very minimal rights-based legislation. And I have often thought that we need something in the act itself that's far more uh, asset building, right? Where people then are, how do you convert the sort of intense destitution in forest areas where people can then make these into assets? And this needs to be both in terms of assets and ownership of land under the IFR, for instance, where, and there is actually a provision where the forest villages can be converted into revenue villages. And the instances of that is so rare. I think there's one in Uttar Pradesh and maybe one in West Bengal, but I'm not even sure of what the situation with those conversions from forest to revenue villages are. But I think one amendment could be that, once people have been given these rights to land, ownership be also be vested with them. So I think that could be a huge asset building exercise, and
So
also
I'm so
with
sorry.
the. Sorry,
I'll
go ahead,
have
Tanya.
to stop you here because
Okay,
the time is short now. We are running out of time. So thank you so much for your time today. And I'm sorry about the initial glitch in starting the session and some confusion that might have led to. And
no problem.
we are glad that a lot of audience members commented it was a very informative session. We did understand a lot. I mean, the audience is taking away a lot from this session. So thank you so much for taking out time on a Saturday evening, sir, to join us for this session, and look forward to more engagements with you in the future.
You're welcome,
Thank you
Tanya.
so much.
Yeah,
I'll end the session here. Thank you, everyone who
sure.
joined us. Have a good evening, guys. Bye bye.
You too. Bye.